Hello, Brian, Councillor Brian. Hello, can you hear me? Let me unmute you. Yeah, it is 3 o'clock.
Hi, Professor. How are you doing?
Hello, Dr. Marota. It's already 3 o'clock, and we are set to start off the session. All right, we are now live, and Dr. Marota, I think you can set up, start off.
Yes, okay. Welcome, everyone. This is our session related to crime of aggression, implication for state parties. Today, we are going to have the presence of Professor Dawar Kanath Shripatri. He's a professor of international criminal law from Singularity University in India. Also, we are going to have the presence of Professor Frimpong. He is a former founding law dean from Jimpa University and the UPS University during the years 2010-2012, and the UPSA from 2015 up to 2020. Then also is joining us Professor Rama Devi Gudamela. She's also a professor of international criminal law from India. Also, we are going to have the companion of Maria Mercedes Pisani. She is from the, she's a professor of international law in Italy. She's part of the Rome Conference delegate of the ICC. Also Professor Alessandra Lanciotti. She is a professor of international European law and international criminal law at the Perugia University in Italy. Then also is joining us Dr. Ditava Ranzane. He works for the government of South Africa at the unit of the Direction of SA Government Legal Services. Also is going to join us Manrit Kaur. She's an international criminal court special legal expert working at the ICC. Then also at the same quarter is Counsel Tony Kirabira. He is a PhD candidate for the Portsmouth Law School in London, and he is a visiting professional in the International Criminal Court. Then we also have the companion of Brian Ramfani. He is an intern for the International Law Research Center in Gabon, Botswana. And finally, we will have also the presence of Counsel Brenda G. Okot. He's a special expert attorney. She will join us from Sweden. And finally, we have the presence of Malesala Leso. He's the Director of Legal Relations, Government International Affairs from the Department of Justice of the Government of South Africa. And also we have the presence of the host and founder of the Center for International Criminal Justice Africa, Professor Milton Owour. He has a PhD in international criminal law. Okay, Professor, I pass the desk to you.
Thank you very much, Dr. Marota, as usual. Dr. Marota is the Director of International Programs, and is a very devout, committed professor and researcher and activist in connection with international criminal law. Thank you very much for co-hosting, as usual. I can see all the professors are now here. It's nice to see you, Professor Dr. Rama.
Thank you. Same here, Dr. Milton. It's really nice to be back and be here for this panel. Thank you so much.
Absolutely. And nice to see you, Dr. Siripati, Professor Siripati. As usual.
Thank you so much, Dr. Milton. Thank you so much.
How are you doing? You all right?
Yeah,
I'm okay. I'm fine. Just fine.
Nice to see you, Brian Rampathe. Ramapani. Brian is a law researcher, international law researcher, very committed. You are going to go a long way if you sit and share with the professors who are experienced as they are. All right, we are live. Ladies and gentlemen, wherever you are, throughout wherever you are in this, on any continent, we welcome you today. This is yet another session when the professors, this is a panel of professors. The professors will be able to thrash out critical issues that relate to the topic, which is a bit complex today. It sounds complex, but it's not complex to the professors. That is the crime of aggression. We are going to look at the implications for the state parties in connection with that particular crime in the context of the Rome Statute. As Dr. Marotta has just indicated, Professor Dr. Milton, I'm the founder director of Center for International Criminal Justice. I'm a professor of international criminal law, and I'm a co-host with Dr. Marotta on this matter today. It's nice to see the professors who have committed their time to come over here, and you are very privileged to have these very experienced professors to be able to thrash out the key issues revolving basically around the crime of aggression. The crime of aggression is a very complex topic, complex because not many lawyers even understand it. It had to go through phases up to where it is, and even up to now, it is still undergoing a lot of jurisprudential interpretation. Briefly, I would just indicate when the Rome Statute, we look at phases. I'm just going to take about 2 minutes to give an introduction, and then I'll usher in my colleagues, the distinguished professors of law, who will be able to feed you with the relevant matter. Now, we have the first phase where we had the Rome Statute being processed through the Rome Conference. During that conference, there was a lot of disagreement as to certain aspects related to the crime of aggression. There was not easy compromise that was reached. In fact, it would have forestalled the whole conference. With respect to the crime of aggression, there was no agreement as regards the definition of the crime itself and the conditions under which the court would be able to exercise jurisdiction in respect of the crime of aggression. So what happened was that that particular topic, that particular crime, although it was listed among the Article 5 crimes, it had to be suspended for a while. The application, the exercise of jurisdiction with respect to the crime of aggression had to be suspended to allow the conference to wind up. And so time was given within which the members would be able to reevaluate and reassess the circumstances and see what they should be able to do in terms of amendments relating to that particular provision. We see that there was Article 5(2), which indicated that the court, it actually gave the court the mandate to be able to exercise jurisdiction in all the listed crimes, the crime of genocide, war crimes, the crime crimes against humanity, and the last one was crime of aggression. So that blanket subparagraph, Article 5, paragraph 2, indicated that the courts will be able to have mandate to exercise jurisdiction over all those crimes. But as time came out, we realized the court had no mandate to exercise jurisdiction with respect to the crime of aggression. So we have amendments. One of the amendments was the deletion of that particular paragraph, as the professors, the distinguished professors, will be able to explain. But what happened again was after a period, there was supposed to be a review of the Rome Conference, the Rome Statute. There had to be another conference that was to be held. And this was the Kampala Review Conference, which was held between 31st of May and 11th of June, precisely 2 weeks, to be able to assess. In fact, it was a stock-taking exercise, and that is how it was referred to. This particular conference was held in Kampala in Uganda to assess and reevaluate what has been achieved with respect to the conference, with respect, sorry, to the statute. And we note that particularly they wanted to address two issues. One of the outstanding issues was the introduction of the drug trafficking offense. That was one area that was not agreed upon. And the second one was now this particular area of the crime of aggression. So during the Kampala conference, there was an opportunity now for the Assembly of State Parties, in fact, the Bureau of the Assembly of State Parties, for members to reassess and re-examine the issue of the crime of aggression, and more specifically to look into the issue of the definition of the crime and the conditions under which that particular crime would be, the exercise of jurisdiction would revolve around it. So we see that now from that conference, a number of compromises were reached in Kampala. And that was, among those compromises, we had also understandings that they were going to use as a basis to be able to amend this Rome Statute with respect to the crime of aggression. So a number of amendments took place, including what I've told you about Article 5, Paragraph 2, and also there were new articles that were introduced. We had Article 8 bis, we had Article 15 bis, and Article 15 ter. Our very learned professors are going to expound on all those issues. But what was critical again was there was like a double regime, as I would say, a hybrid kind of jurisdiction, a legal regime. There are two issues here. We had the issue of the consent jurisdiction, so that a party would be allowed to be able to consent before this particular offense would be exercised, the jurisdiction would be exercised over it. So unlike the other three offenses, which would just, the court would automatically have jurisdiction, with respect to the crime of aggression, and for the sake of achieving compromise, one of the key factors is that there is a consent regime with regard to this offense, in the sense that you can opt out, a state can opt out and say, I don't want to be affected by that particular offense. And also the other key feature was that non-state parties are not affected by this regime of this new offense. So we have all these contained, as our professors are going to elucidate. We have also two approaches. The conditions surrounding the application of that particular consent with respect to, the offense with respect to the trigger mechanism. We have three trigger mechanisms. So we see that one of the sections deals with the state referral. It's only state members, state parties who can refer the offense to the prosecutor, and then the jurisdiction would be conferred. There are a lot of conditions that differ from the one that is initiated by the Security Council. We have the option where the Security Council may trigger the offense so that jurisdiction is exercised by the ICC. All these will be explained to our viewers. So it's going to be a well-charged session. We have already well-experienced professors with us already in the panel. They are already here, and we are having more coming to join us a little bit late. So we welcome you. Thank you for your time. We know you've devoted your time. There's so much to learn from here, and we are very thankful to the professors on this panel. I'm very, very thankful to Professor Dr. Sripathi, who has been contributing all through. I'm very thankful to Professor Dr. Rama, who has not been well, but has recovered. And she's very eager to be here. She's always been very eager to come on board. And we are very, very happy to see you. And we know you've been making very, very productive contribution here. And your viewers have missed you a lot.
Yeah. Thank you. Thank you so much, Dr. Milton. It's so nice to receive this comment. Thank you.
Yes. Thank you, ladies and gentlemen, distinguished professors, my colleagues, the professors of law. And thank you, Brian, for being there. Thank you, Dr. Marotta. I now hand you back to Dr. Marotta, the very committed Director of International Programs, so that he can co-host. Thank you, ladies and gentlemen.
Thank you. Thank you, Professor Milton, for your great intervention here in the conference. Well, coming back to the matter that are gathering us here, the crime of aggression, implication for state parties. As I want to add something about what just said Professor Milton. We are now in new kind of scenarios that back in 1974 during the General Assembly Resolution 3314 was defined the crime of aggression. That time was another space time, so we can quantum physics, that we can explain how the humanity after the terrible wars that were before that Second World War II, then all the wars later by independence by countries, North Korea, Vietnam, and so on. There was a logical way of seeing the crime of aggression. Nonetheless, nowadays we are in another kind of scenario. So the question here is for the professors that are sitting around us, is how do you see the future of crime of aggression with the new kind of society where we are facing now? We are facing a society of the cyber warfare. It can be considered a crime of aggression. For example, I don't know if Mexico makes a massive cyber attack, not to the States, but I don't know, to another Central American country, even though they don't have any kind of border, could be considered crime of aggression. For example, they make probably a massive attack, so they can shut down all the electric power. So if you shut down all the electric power, you can, in some hospitals, if they don't have any electrical equipment, many people will die. So that's an example. Nowadays, we know that everything is automat. Everything is controlled by computers. Water services, telecom, communications, electricity. So that's one question. What do you think about that? So that, for example, and how this country, under the principle of jus ad bellum, the right to go to war, and in the same time the jus in bello, the rules of engagement, how these other countries could respond to that attack. We can say the equality of arms. They will need to use the same cyber warfare to repel the attack, also to do the same to, for example, Guatemala to Mexico. I'm doing this example of Central American countries. Or they can have the right to, I don't know, to use military forces by drones bombarding the centers where this was allowed. I don't know, because I was searching I was reading the definition of aggressions, and practically it's more that what we conceive in the past, in the last centuries, the concept of war. It recollects all the Geneva Conventions, the 1, the 2, and the 3, related to how you will treat the prisoners of war, etc. But now we live in another scenario. Everyone right now, it's under lockdown, under this new pandemic disease that in some forums in the internet they said it was created. It's kind of also a kind of, I don't know, crime of aggression from China to the Western society, so they can alter their economics. So I leave these questions over the desk so we can have some answers, because I think this is what the challenges of us as professors. I remember all of my professors in law, they always say that the law always was behind the real things that happen in society. So now it's the time so that we can be one step trying to figure out how this will be, the crime of aggression, evolve in the coming years. There is another speculation that probably the West will enter in another Cold War, I don't know, against China under the COVID-19 situation. So the geopolitics, it's moving right now. It's very alive. If you do some Google search in the internet, what also is going on in Russia? Putin, once again, he wants to chair the presidency, and all this new scenario, if for example, if the vaccine against COVID-19 will say the Russia version will succeed, how the change of a scenario for some countries having that vaccine, others not, it will be considered as a crime of aggression. I don't know. I mean, these are questions that I'm leaving in the desk, and someone will like to answer it. For example, cyber warfare could be considered a crime of aggression, and under the principle of jus ad bellum, and then if there is an engage of war of using bello, I mean, the country that have the aggression of the cyber warfare could have the right to defend themselves by using the power of the armed forces. I don't know, sending an airplane, sending their aircraft to bombard the places where they have the knowledge that they are doing these massive attacks. So I open the desk to any of the professors who wants to answer these questions. Thank you. Professor Shivati.
As usual.
Yes, the system. I mean, you know what I mean now. IA directly choosing
Not for nothing.
Yes.
Okay, I'll make the start.
As usual.
Yeah, that's very true. Good evening.
Good evening, sir.
Good evening, Professor.
All the panelists, and nice to see you, Rama.
Thank you, sir. Same here.
After missing out on 5 sessions, I suppose.
Yeah, approximately 5 sessions. One whole month.
Yeah. Good evening, Brian.
Good evening, sir. How are you?
I'm fine. Okay. And good evening to the host and the co-host.
Good evening, my prof.
Good evening, Professor.
Now, the crime of aggression has been a very controversial issue as far as the jurisdiction of the ICC is concerned. The decision to include the crime of aggression in the statute of the International Criminal Court was taken in the year 1998. But the states were very doubtful because the definition of the crime of aggression was not clear to the states, and therefore they did not want to commit themselves to any kind of exercise of jurisdiction by the ICC, and therefore they kept it aside. And it was only in 2010 that a decision was taken to give a clear, precise definition to the crime of aggression. And a decision was taken in 2010 when the review conference of the ICC took place in Kampala. But here again, the states somehow were not very confident of making the crime of aggression, binding upon the state parties. And therefore, they deferred it for another 7 years, till 2017. In 2017, no doubt during the Kampala conference, a precise definition was certainly given to the crime of aggression, but they did not want the crime of aggression to be implemented. So they deferred it by another 7 years. And in 2017, the states, in a momentous period of 2 weeks in 2017, the decision was taken by the states to implement the crime of aggression against the state parties in case where the crime of aggression is perpetrated by any of the state parties. And it took another 6 months for the crime of aggression to become operational. That is on 17th July 2018, the 20th anniversary after the adoption of the statute of ICC, the jurisdiction of ICC over the crime of aggression became operational. For the first time in 70 years, since the Nuremberg trial and the Tokyo trial, an international criminal tribunal would have the possibility of prosecuting leaders who perpetrate the supreme international crime, that is the crime against peace, which today is known as crime of aggression. Now, this crime against peace has been a part of the Geneva Conventions of 1949. It was very much a part of international humanitarian law. Crimes against peace, then crimes against humanity, war crimes. But somehow the tribunals were not in a position to pin the liability on the perpetrators of the crime. There were a lot of complexities, difficulties. There was not sufficient evidence to attach liability to any leader of a state. Now, those leaders who are guilty of planning or executing an act of aggression, which by its character, gravity, and scale is a clear violation of the Charter of the United Nations, shall be punishable. Now, if one looks at Article 2, Clause 4 of the United Nations Charter, it clearly says that all member states shall refrain from using force or threat of force against the territorial integrity and political independence of any other state in any manner inconsistent with the purposes of the United Nations Charter. So crime of aggression is nothing but use of force by one state against another state. And since this is a clear violation of the United Nations Charter, I do not understand why states are taking so much time to hold the perpetrators of this crime liable. Of course, through the Rome Statute, there is a kind of apprehension among the states that today if they make the crime of aggression a reality, then the court may use the same against the state. So that fear is always lurking in the minds of the leaders who head the states. Now, if we go into the past, that is the League of Nations, which was established in the year 1920 for the purpose of maintaining international peace and security in the world. Now, the League of Nations derived its powers and jurisdiction from the covenant, like how we have the Charter of the UN. The League of Nations had a covenant. And one of the major drawbacks of the covenant of the League of Nations was one provision which permitted use of force. Of course, partially, if not totally. What the provision said was, if two states which are in dispute shall try to settle the dispute by employing all the specific methods of settlement of disputes like arbitration, negotiation, conciliation, and mediation, and sometimes good offices. Where if the states fail to settle their dispute peacefully, then after an expiry of a period of 6 months from the failure of the settlement of the dispute, the states can resort to war. They can go to war. So the covenant did permit use of force. Now, in 1945, when the framing of the charter started in 1943 itself, where it was finalized during the Dumbarton Oaks proposals, and finally it came into force in 1945. The framers of the United Nations Charter did not make the same blunder that the framers of the Covenant of the League of Nations made. The Charter completely prohibits use of force under Article 2, Clause 4. Any kind of force that is employed by one state against another state is totally prohibited. But despite the Article 2, Clause 4, states have been violating the provisions of the United Nations Charter. Now, the question is, how does one assess the effectiveness with respect to prosecution and punishment of the crime of aggression? Now, this has been a big question before the ICC. Because, as pointed out by Professor Milton, the definition of crime of aggression is very complex. There are so many dimensions and issues involved in the crime of aggression that it is very difficult to give it a very precise legal definition so that it will be easy for the court to exercise jurisdiction. And because of the complexity, there is a lot of problems. So how does one assess the effectiveness with respect to prosecution and punishment of the crime of aggression? That is one question. Secondly, how does one assess the compromise that resulted at the ICC review conference at Kampala? I mean, what went into the negotiations and deliberations in respect of the definition of the crime of aggression at the review conference in Kampala? What was the compromise between the states? So these two issues are something that needs to be discussed. So I leave this to the other panelists, and I will deal with another major problem. That is the condition that is laid down that a previous determination by the Security Council on the occurrence of a state aggression or the ICC's intervention. Now, where there is an instance of a state employing aggression against another state, the ICC, despite having all the evidence, cannot proceed against the state unless the Security Council has first determined whether the act committed by the state amounts to state of aggression or not. Now, this precondition is also a kind of a deterrent to the jurisdiction of the ICC. And in the absence of a Security Council referent, the exemption of non-state parties from the court's jurisdiction will substantially reduce the ICC's power to intervene and create circumstances where the Security Council may feel tempted to use frequently its power of deferral under Article 16. Now, it's very clear from this Article 16 that if there is no Security Council referral, then the exemption of non-state parties from the court's jurisdiction will substantially reduce. because we have seen in the past that in the case of non-state parties, the court cannot exercise jurisdiction. But if the Security Council can make a referral to the ICC, then the ICC can exercise jurisdiction. But in the absence of a Security Council referral, the ICC becomes toothless, at least in the case of non-state parties, because it cannot exercise jurisdiction. And the Security Council, because of the power that it has under Article 16 of the statute, will always feel tempted to exercise its power and therefore acts as an impediment or an obstacle for the ICC whenever the ICC would like to exercise jurisdiction against any state for the crime of aggression. Now, according to the Rome Statute, the criminal liability for the direct and indirect perpetration of the crime of aggression seems to be restricted to individual who exercises control over a state. This is what the Rome Statute says. That is, criminal liability for direct or indirect perpetration of the crime of aggression is limited only to an individual who heads the state. But however, if you look at Article 8 bis referred to by Professor Milton during his introductory address. Now, Article 8 bis of the Rome Statute defines the crime of aggression as the planning, perpetration, initiation, or execution by a person effectively to exercise control over or to direct the political or military action of a state of an act of aggression, which constitutes a manifest violation of the Charter of UN. Now, according to this article, again, the liability is with regard to a person effectively to exercise control over or to direct the political or military action of a state. That is, a military head or a head of a state who are in the position of power and who can exercise that power. Only they can be held liable. But today, the situation has changed, as pointed out by the co-host, Dr. Marotta. He made a reference to cyber warfare, and now what I feel is the criminal liability that is attached only to military heads and heads of states makes the provision of the Rome Statute very limited and restricted. The reason being that today corporations also play a very prominent role in fueling conflicts in the world. The corporate bodies, in other words, the transnational corporations, because of the enormous concentration of economic power in their hands, they literally play with the governments, the national governments of the countries where they operate. Because we are aware of the fact that a transnational corporation is a corporation that has its units on the territories of mostly the third world countries. And these transnational corporations legally are not supposed to interfere in the political or internal affairs of the host state. According to the United Nations Draft Convention on Transnational Corporations, they are not supposed to interfere. But they do interfere in the political and internal affairs of the host states, and their participation is by way of, exploiting the natural resources of the host country where the unit is operating. Apart from that, there are other corporations apart from the transnational corporations who specialize in manufacturing weapons. So they are indirectly helping states in fighting a war. And these corporations are going scot-free, the heads of the corporations, and they are not being held responsible for the crime offense of or the crime of aggression. So they also should be brought under the jurisdiction of the court. In a sense, probably another amendment has to be made to Article 8 where apart from military heads and heads of states, corporations also should be made liable if they are guilty of fueling conflicts between states. And the crime of aggression under the Rome Statute is a crime committed against the sovereignty of a state. This is very clear from Article 2, Clause 4 of the United Nations Charter. Because every country is independent and sovereign, any kind of force that is used against the territorial integrity and political independence of a state amounts to violation of the principle of sovereignty of that state. But today, war is not simply a fight between states. Non-state actors, including non-state armed groups and corporations, are increasingly engulfed in armed conflicts. So non-state actors, non-state armed groups also who fight a war, and they also are very much capable of perpetrating the crime of aggression against another state. So they are also missing from the definition of the crime of aggression under Article 8 of the Rome Statute. Now, the transnational corporations today are more powerful than the states, some of the states. And apart from that, we have certain intergovernmental agencies, and these intergovernmental agencies are also more powerful than the governments of the states that have created this intergovernmental agency. So sometimes there is a possibility of the intergovernmental agency going overboard. And it is because of these issues that I strongly feel that the definition of the crime of aggression under Article 8 of the Rome Statute should be expanded and should include non-state actors also. That is my submission. Thank you.
Hi, thank you, Professor Shivad. I was talking to myself. To unmute. Thank you for that great intervention that you have made. Also, I want to give the welcome to Manrit Kaur. She just there she is. She just joined us to the panel. Anyone else who wants to add an additional point of view related to what Professor Shipati has told us today?
I just, Sir Sripati Dwarkanath sir, he has made a comprehensive, complete idea about or complete details in toto. I would say that but just a little bit addition to what the professor has said. So my view here is just to make this, just to provide an overview as to how the position of crimes relating to aggression is dealt under international law. Most of it is covered by Sir, so just an outer line I will be trying to give an insight into. Primarily, there are, if the crime of aggression, if it is committed, uh, hello, can you hear me?
Yes,
Yes, yes, we can hear you.
yes.
Hear you?
Loud, sound and clear.
Loud and clear.
So, yeah, suddenly the screen went off, so I was really confused.
No
Okay,
problem.
so primarily, I would say that how the crime of aggression is dealt under international law, it is not accepted even in the United Nations Charter, and neither it is acceptable, and it is considered as a crime which can be tried before the International Criminal Court according to the Rome Statute also. So the position is clear now that crimes relating to aggression is very much within the jurisdiction of ICC, that is Criminal Court, International Criminal Court. But coming to the jurisdiction on whom the International Criminal Court can exercise, it is purely on the individuals who have committed the crime. Okay, and so here one question which comes into being is, can the head of the state be made liable if the state is the direct perpetrator here? Whoever has committed whichever crime of aggression has been committed here in place. So when a state is committing a crime of aggression against the other state, no doubt even the International Criminal Court, even the International Court of Justice can provide its judgment and make the state liable, just as in case of Nicaragua versus USA, the armed rebellion which was sent by US, it was not accepted and US was made liable there. So the aggression or relating this kind of crimes, if the other state is a perpetrator for committing of this crime, then no doubt even the ICJ can exercise its jurisdiction against the other state, and the state responsibility can be imposed on the other states which are perpetrating to this kind of crimes. But if the crime of aggression is limited only to a particular country, that is within a sovereign nation, if the crime of aggression is taking place among the belligerents or the insurgents, whoever are there, then the question here before ICJ would be on whom the jurisdiction should be exercised. Then it will be against the person whoever has committed this kind of aggression or armed conflict within a particular nation, which within a sovereign nation. Okay, so now whether the ICJ can, when during the prosecution, generally, if it is found that the perpetrator is directly the state, okay, then can this head of the state be made liable according to the convention which is there in place, and can the jurisdiction be imposed on him? That is one such debatable question here. As Sir has mentioned, transnational corporations, along with the people who can exercise the military control, along with these individuals, can the head of the state be equally be made liable? And if this is the question, then no doubt it is nothing but interfering directly with the sovereignty of a particular nation. Okay, so this breach of a sovereign affair relating to a nation is interfered, and can the ICC extend to this level? This is one debatable or issue in place. Other than this, if there is much more crime of aggression which is taking place in a particular country, can the Security Council interfere and take any action against the state for continuing this kind of aggression? If provided it is a crime relating to genocide and it is affecting the humanity, the whole of the world countries are getting affected because such a crime is committed in a particular country, only then the Security Council can interfere into the sovereign affairs of a state. Or else, if it is a proper state under international law, then even the Security Council would not directly interfere if it is an armed conflict within a particular sovereign nation. So this is what I would just like to put forth. And these are some debatable questions here which are not solved. And to date, we see that why Security Council is still not interfering with the states where there is heavy crimes of aggression which are going on, especially the states which are not a party to the Rome Convention. So here also it's a problem now. So until and unless the matter is referred to Security Council for the interference by the world community, only then it is going to interfere by exercising its power over such a country which is violating the rights of the people by using this aggression as a crime, or using the violence as a crime within a country. So this is what I just wanted to put forth my view, and I leave it.
Okay, thank you, Professor
Sir has done.
Ramadevi Guadamela for your great intervention.
Thank you, Marota, sir. Thank you, Professor Marota.
Thank you. Anyone else who wants to add what just Professor have shared with us?
Yeah, I would like to, what you say, speak on something that my student and now my colleague, Professor Rama, has stated. She referred to the US versus Nicaragua case where the US was found guilty of sending mercenaries to the state of Nicaragua to add to the disturbance that already existed on the territory of Nicaragua, because Nicaragua was in a state of war. There was a civil war going on. So these mercenaries further disturbed the peace in Nicaragua. And when the Nicaraguan government realized as to what was happening, they referred the matter to the International Court of Justice. During the arguments before the ICJ, the US Counsel argued, saying that in order to restore peace in Nicaragua, we sent our forces, which was a blatant lie. And however, the court was not happy with this argument of the United States Counsel and said that even if there is disturbance on the territory of the state of Nicaragua, Article 2.4 of the United Nations Charter prevents a country in interfering in matters of another country. The US had no business to go and interfere in the state of Nicaragua and held the United States liability and ordered for compensation. US had to pay compensation to the state of Nicaragua. It was held responsible for the damages caused to Nicaragua. But the US refused to implement the judgment of the International Court of Justice. And what is the enforcement machinery of the International Court of Justice? It is the Security Council. So the court requested the Security Council to enforce its judgment against the US. And enforcement of judgments of the ICJ being a substantive issue or a substantive matter before the Security Council, 9 votes out of 15, including the 5 votes of the permanent members, is required. So when the matter came up before the Security Council, the US, being a permanent member, exercised its veto. And the Security Council could not take any decision. The whole exercise went down the drain. So on paper, everything looks good, but in reality, something else happens. These are international politics. Same thing is happening with ICC today.
Yeah.
Similar situation is being faced by ICC today.
Exactly, right, sir. Most of the ICJ judgments are not enforced just because of this reason that the veto power is exercised by this permanent members of UN or the Security Council.
Absolutely.
So
it frustrates.
Another issue I would like to dwell upon is that the jurisdiction of the ICC is not based on the principle of voluntary acceptance. States do not voluntarily accept the jurisdiction of the ICC. The Rome Statute, in fact, imposes obligations on non-state parties without their consent. This has been a very controversial issue as far as the Rome Statute is concerned. Without the consent of the non-state parties, the court exercises jurisdiction or imposes obligations upon those non-state parties. So this is nothing but a clear violation of the principle of sovereignty of a state. And also a violation of the Vienna Convention on the Law of the Treaties. Now, the complementarity jurisdiction principle gives the ICC the power to judge whether a state is able or willing to conduct proper trials of its own nationals. The principle of complementarity, only when a state fails to try its nationals or where it is unable to try its nationals, then the court steps in. So the discretion to judge whether the state is able to or refusing to try its nationals is given to the ICC, which is again a bit controversial. Because once a power is given to the state, let the state decide. So these are the issues that actually plague the smooth functioning of the International Criminal Court. Thank you.
Thank you, Professor Shipatri. I think Brian wanted to add something. Brian.
Thank you very, very much. Am I audible?
Yeah.
Yes, we listen to you.
Very
yes, perhaps for this discussion, it is very, very imperative that we look at the submissions that were made by the delegates during the Kampala conference, looking at the jurisdiction. We are going to look at where some delegation expressed the view that the court may not, in any circumstance, exercise jurisdiction regarding crimes committed by nationals on or on the territory of state parties which have not ratified the amendments as in accordance with Article 121, paragraph 5. If you can go back to 19 October 2017, France and United Kingdom jointly presented a paragraph as an element of a possible activation decision. It was explained that this paragraph will clarify the exercise of jurisdiction of the court over the crime of aggression, according to their view, that it could not extend to nationals of state parties which had not ratified the amendments. That's the first view. And the second view is where some express that the court may exercise jurisdiction over the crimes of aggression committed by nationals of a state party which had not ratified the amendments, unless the party had previously declared that it did not accept such jurisdiction in accordance with Article 15, paragraph 4. Then thirdly, some delegation argued that the key question was not whether or not the state parties had ratified the amendment or whether they were bound by it, but rather how the court derived its jurisdiction under the Rome Statute, namely by the virtue of the principles of either territoriality or nationality set out by Article 12 of the Rome Statute. It was recalled that in respect of genocide, crimes against humanity and war crimes, nationals of non-parties, for instance, would be subject to jurisdiction of the court if they committed such crimes on the territory of a state, having ratified the Rome Statute. Thirdly, other delegations argued that state parties will not be in a position at the time of the Rome Conference to accept in advance the jurisdiction of the court in respect of the definitions and conditions for exercise of jurisdiction as they had not been agreed. They argued that this will run counter to the principle of complementarity and would mean that the activation would expose individuals to, in non-ratifying state parties, to international criminal prosecution where their national parliaments had neither expressed consent nor put in place implementing legislation to enable national prosecution. So the interesting clash here is going to be what is found in the Vienna Convention, that a state should consent to be bound by whatever treaties that, whatever whatever terms are found in the treaty versus the idea that the ICC will have jurisdiction either way. So I think it's an interesting clash that my learned colleagues here would want to submit on. So it will be a clash between the state being sovereign to make its own decision on whether or not it's bound by the amendments, and the fact that the ICC would have jurisdiction either way, despite the fact that it had not, other states had not accepted the amendments. One of the most important things to note is that only 30 states, I think, had at the time consented to such amendments. So the issue will be whether or not states who had not consented to such amendments should be bound by whatever was discussed in the Kampala conference. Thank you very much.
Thank you, Brian, for your sharing us your point of view. Well, I have like a flashback doing with this discussion of criminal progression. I remember in 12 years ago, approximately 2000, I think it was summer for Latin America, between January and March of 2008, Colombian troops were prosecuted. They were in a hot chase against the FARC militia, and you know that the border between Peru, Colombia, and Ecuador is the jungle. So it's a very deep jungle. So they're very deep rainforest, and the soldiers under this hot chase, they got lost. They passed the border. They thought that they were in Colombian territory, and they killed I don't know, well, they were like 50. It was a very significant troop members of the FARC, even though there was this mercenary camp of the FARC in Ecuador, and they bombarded it. And so I was trying to search the document through my archives from the Andean Commission of Jurists, because we when this happened, I was in charge of the International Criminal Court and the Andean region, and this was brought to the desk. And in those days, it was before the Kampala summit, and in those days there was like, you know, like a voice from Ecuador trying to evoke this crime of they considered that the killing of this terrorist group, in even also under this situation, it was a Dutch person who was killed because this Dutch person was part of the FARC. They tried to evoke the crime of aggression from Colombia against Ecuador under this figure of hot chase. You know, hot chase, when you're, the hot chase always happens when the police or the law enforcement is behind and they're shooting and they're trying to grab a felon. But in this case, the scenario, it was very, here in Latin America, I remember it appears in all the media, even though Peru and Brazil needed to do like diplomatic channels and diplomatic negotiations to cool down the situation, because I remember the former president of Ecuador, I don't remember his name, who is actually living in Belgium right now. I don't remember his name right now. I have forgotten the guy's name. He is waiting, you know, to be tried in Ecuador by a corruption case that happens here in Latin America. And you can watch it through Netflix. I don't remember the name. It's the Lava Jato, but you can search Netflix and you will see all this machinery of corruption done from Brazil to all the Latin American. Anyway, so I bring here the question also for the professors, if they can answer this question. So now that we have the Kampala conference, if this scenario happens again, I'm giving this example because it was a very good example that happened 12 years ago. Colombian troops, special forces, they were trying to grab this part of this group terrorists, these members of the FARC. They sometimes some points because of the region, the border, even though it's this rainforest, it has higher peaks because of the Andes mountains. They get lost. They don't have very good location of their GPS, so they cross the border and they saw the crossfire. They gave the position to the helicopters that were supporting them, and the helicopters bombarded all these fire camps, killing these Dutch citizens, for example, that was killed under this rampage, and many other Colombian members of FARC. That the camp was in Ecuadorian territory, because when they did with the satellite, all the military action took place in Ecuador. So at that moment, was before the Kampala, was 2008. Ecuador made the international communication, also addresses to International Criminal Court, saying that Colombia made a crime of aggression in their own territory. Even though the people, the guys who died there, no Ecuadorian citizen, it was only, they were Colombian because and the Dutch citizen, terrorists from the FARC. So under these circumstances, if this happens again in any part of the world, in a hot chase from country A to country B, it will be, now that we have a very much broader picture of crime of aggression, it will be considered a crime of aggression. The only presence of military forces within a territory exchanging firefighting between, I don't know, a terrorist group or a militia from that country in the other country. How do you see it? Will we consider a crime of aggression or not? Anyone? I see Professor Milton, he is waving.
Yes, Doctor. I'm just mesmerized by your presentation. It's powerful. Thank you so much, professors. Thank you, Dr. Sripathi, Dr. Rama. You presented Mr. Ramapane. Those were very awesome presentations. But I just want to, I will take this opportunity to recognize the presence of Marit Kaur. Welcome after a while. Nice to see you. Marit is a counsel at the ICC. She's an assistant counsel there. And it's nice to see you. She's been with us, very active member of the panel. Welcome, Marit. We can't hear you. Let me unmute you. Let me unmute you. Let me unmute you. Can you unmute? Unmute. Oh, all right. We can now hear you. Let's hear your voice, Council Marit.
Yeah, hello to everyone. Yeah, hi.
Hi.
Actually,
Hello.
now in India, the situation is getting normal back after the corona pandemic situation. So it's now getting better. Courts are now opening. So it's not regularly working, but it's working in a rotation and in a partial way. Means the court working is in the partial way. That's why my schedule in the last 2-3 Fridays was busy. That's why I was not able on the panel. So very nice to see you all again.
Absolutely.
And I'm listening all of the experts, crime of aggression, although I am not very much expert on this topic, but still I am listening, and I'm getting a very much necessary knowledge from all of the experts. So,
And we hope to hear from you too very soon.
Yeah. So I can see crime aggression. It's a totally very different crime from all over the international crimes. It's a very different crime. And when the ICC has admitted this crime, it's a very nice gift given to the victims. Because the ICC has admitted this crime. It's a very nice gift given by the ICC. So we can see aggression word was first came into the picture in the International Military Tribunal. So and in the Tokyo trials, in the Tokyo tribunals, and in the Nuremberg tribunals. After that, the aggression word came into the picture in the international criminal law. So as Ms. Rama ma'am was talking about the jurisdiction of the ICC, there are the three ways of the ICC can have the jurisdiction. ICC can have the jurisdiction on the crime of aggression. So the court may have exercised jurisdiction over the crime of aggression. Firstly, we are very well aware about this part. If the ICC member state referring a situation to the court, and second one, if the prosecutor initiating an investigation, that is a pro priori motu. If the prosecutor is initiating on self, this situation is a threat to all over the world, and then the prosecutor initiate the investigation. And third one is the United Nations Security Council referring to the situation to the court. These are the three ways the ICC can have the jurisdiction. And the best thing of this crime of aggression, best thing of the Article 8 bis 3 is that ICC can try to the individuals, not on the states. Only this section in which the individuals can be tried by the ICC, not the states. And most of the part of the crime aggression is covered by the Dr. Ramadeh ma'am and the Professor Sripathi sir, and I'm just listening them, and I will add more and more once. And today this one is from my side.
Thank you. That's awesome. Let me also have this opportunity to introduce Brenda Grace Counsel. She's just joined us. I think she's still driving, isn't it? Let me unmute you.
I think Brenda is still driving, yes.
All right. And last but not least, we have with us Professor Dr. Frimpong. He's here with us now. Welcome, Professor. Can you hear me?
Yes, I can hear you. Can you hear me?
I can hear you, and nice to have you, Prof.
Okay, thank you for welcoming.
All right. Thank you very much. It's good to have the professors here. Now, I've listened to what the other professors have been presenting, and they're very erudite indeed. What I want to do, and also what Dr. Marotta has just posed over to the panel, I just want to provide an analytical framework, skeleton, that should be able to reinforce the way we move with those questions that you brought in. This is from my side. I'm not imposing anything. I would want to look at this whole matter of the crime of aggression in a framework in this form. The first is to have a retrospective glance as to why this particular crime was problematic to the conference. So when we go back in retrospect, we'll see that during the Rome conference, the problematic aspects of the crime of aggression revolved basically around the definition of this crime. And as Professor Sripathi might have put it, there are quite a number of fears that some members might have entertained. The fear of the unknown or the expected repercussions coming to them. So precise definition of what entailed this crime was something that remained outstanding from the Rome Conference of 1998. The other aspect was also the conditions under which the ICC would be able to exercise the jurisdiction. So you find there was this baggage carried over from the Rome Conference onto another conference, the Kampala Conference that we had. And also, as the professors have put it very ably, so I'm looking at our arguments being architectured around the background, what caused it, and whether we've really solved this problem, or we are still in the process of exhaustively solving the problem that was posed in the light of the crime of aggression. So we see that, as Professor Sripathi put it rightly, the Rome Conference gave itself time so that the statute would be re-evaluated, reassessed after a period of time. Actually, after about 7 years, the conference was supposed to be reconvened, or a bureau of kind, as was done in the Kampala Review Conference of stock taking. It was called stock taking, to establish what had been done to that point and what challenges were carried over, and whether those challenges would be confronted to surmount the impediments that were on the way. And one of these impediments, which was a carryover, was still this crime of aggression. What constituted this crime? What was the definition that was still hanging? And what were the conditions? Because the issue of conditions, you'll see as we go on, the conditions issue here brings in the question that the professors, the learned professors, touched about consent. The issues about consent come into fore. The issue about who actually should exercise what and at what time comes into fore. So you find at the time when Article 5 was developed at the initial Rome Conference, as I said earlier, the crime of aggression was already listed there. But there are certain, if you looked at the statute as a whole, there are certain provisions that, when interpreted, actually produced what I would call absurdity in the language of drafting. You can have a provision that, when you try to interpret, all you have is absurdity. It becomes an absurd, result is what you get from that. So paragraph 2 of Article 5 indicated that the states, that rather the ICC had power or jurisdiction over those crimes that were listed, and that included the crime of aggression, which was still outstanding. So I think when we analyze, first of all, we have to look at what was the problem that brought us to Kampala Review. So when the Kampala Review Conference was held, the target was to be able to find a compromise. Actually, what we have at the moment is simply a compromise of a delicate negotiation process that they had at that conference. What are these delicate compromises they had? They had some understandings that were listed. When you look at resolution RC/resolution 6 of that, there are a lot of annexure to that resolution. There are some understandings that guided that whole conference towards coming into a compromise. So again, in our analysis, I believe our professors will also be able to delve into what were the technicalities that were entailed in these negotiations, in this compromise, because we can see still more compromise coming in. As we said, there was suspension for 7 years. The crime was listed, but it could not be activated until after certain conditionalities were met. 7 years elapsed, and still they're not in a rush to have it work out. Now, this is a bit, I don't know how to describe it, but it is a bit unusual. So they had to do whatever they would do to have factors militating in favor of moving forward. And one of those was how to activate this particular crime, which was already with them within the statute. So the complications were the issue of consent, which was raised by one of our professors in this panel just a few minutes ago. One of the conditionalities was what constitutes. So we have what I would call, let's look at the definition clause. So the definition came up, there was an attempt to define precisely. As Professor Sripathi was mentioning, there could be the issue of who is being targeted. I think Dr. Rama as well was on that, Professor Rama touched on that. Really, the target of this particular jurisdiction is the individual, as Professor Rama put it rightly. So we have to look at the issue of who is targeted, what's the definition? Which conduct is being prohibited by this particular provision that's prohibiting crime of aggression? Well, it might be the state apparatus being in force or being in operation, but they are particular individuals. So this is where we have the definition clause. In fact, I would call it the leadership clause. This particular provision, which was included in Article 8 bis, talks about who, when we talk about leadership, they have to identify, because there are two things here. Apart from the leadership clause, I'm looking at the threshold clause as well. We cannot, just like the ICC does not get involved in all offenses, it targets on the key players. So we find, let's look at the leadership clause. As the professors ably put it, the leadership clause that is being focused, as we analyze, we'll be looking at the issue that is people who effectively are in control of the political and military apparatus of the state, who can influence things, who can influence decisions. So we have people placed, and it is that it cannot be one individual. It could be, there's a clarification that there could be more than one. But the way the statute puts it, it would appear that a particular person who is in control of maybe the military as the commander, but it could be a number of platoon commanders who had effective control of the direction. Maybe they were in command at a given time and took a decision to move. So the ICC would want to get hold of those individuals. But having in mind the issue of the threshold, so that you don't just sieve and get every Tom, Dick, and Harry. We get the threshold idea is to be able to get the key players and also to reduce the burden on the ICC. So our analysis will look at those clauses, the leadership clause, the threshold clause, and apart from that, there's the conditionality. As Council Maurit was putting across, like also my other colleagues, my learned professors, we have the 3 trigger mechanisms. We're also going to look at it. The way it's being applied in respect of the offense of crime against aggression, the crime of aggression rather, is not the same as the rest of the other 3 crimes. How? Because it's a bit peculiar. First of all, the condition, even before we come to that, there was that conditionality that was placed at the conference that there are 2-step conditions. One, before the crime would be activated, it was demanded that there should be further ratification. You can see the whole statute had been ratified, but now there was another demand for ratification of that particular provision before it can come into effect. The countries had to literally put in the ratification within a period of 1 year. So after the ratification, there was the second stage that was placed. After the ratification, they demanded again, but those were steps taken for the purposes of very delicate compromise. Then it was demanded that the whole conference, all the members would again sit and approve that whole structure. So we had one stage of at least 30 members meeting that ratification threshold. And after that, we have the conference, which was finally held in New York, where we had the ASP approving the whole process. So it was the conditionalities here and there that helped to patch up a very delicate compromise. So the other issue that we may need to inculcate in our analysis on the aspect of conditionality still goes back to the issue of the trigger mechanism. The way the trigger mechanism works under the crime of aggression is totally different from the others, because when you look at Article 8, Article 15 bis, it will provide in terms of the 2 trigger mechanisms that are lumped up together. One, the proprio motu, the way Council Maurit put it very ably, and the other one is the normal state referral, just like other offenses. There are a lot of conditionalities involved there. For the state to be able to make a reference, and also the prosecutor start proprio motu, there are stages like, for instance, there would be need for the Security Council to be able to determine that that particular offense had been done. And apart from that, there is also the condition that non-members are not involved. You see, in other offenses under the statute, we can engage non-state members, non-state parties. We can have their individuals or their nationalities brought before the ICC. But in this case, no member is involved in terms of these two trigger mechanisms. You cannot, one of the things is you can opt out. There's the opting out clause. That's the consent-based regime that I was talking about. In juxtaposition, these complications are just, it's so intertwined. So a state may not be bound if it chooses to opt out of the regime of the crime of aggression. You can say, we are not going to be bound by that particular regime, and you do nothing about it. As long as that particular declaration is lodged with the registrar before the act of aggression has taken place. And that happens as well. The proprio motu is the same process. It would give time about 6 months for the Security Council to be able to determine. And in the event that the Security Council does not determine within 6 months, the prosecutor would approach the pretrial, division for an authority in the same process as it does. But now come to look at this. Those are two lumped up under Article 8 bis, but 15 bis. When we look at Article 15 terror, it now focuses intensely on the powers, on the procedure of the Security Council. When it comes to the Security Council, that same rigidity, which we see, the rigid framework that governs 18 terror 18 bis does not apply to it. The Security Council would be able to go ahead as long as it has determined that that is an offense. It would refer the matter to the prosecutor. And then the other thing is there will be no other complication. One, because the rationale is that the Security Council has invoked the powers under the UN Charter that allows it to maintain that peace and order. So I'm just trying to show you how complicated, there's a complicated web of analysis involved in this. That's my contribution that I can make to guide the whole process of analysis. Dr. Marotta. Thank you. Thank you so much. Unmute, Dr. Marotta.
Okay, thank you, Professor.
Yes.
Professor Milton, for sharing with us. Okay, anyone else wants to add something related to the crime of aggression?
I would like to add something.
Okay, Professor Shipati.
Now, the decision of the state police during the 1998 negotiations include the crime of aggression in the Rome Statute actually weakens the power of the Security Council. Because much before a case of a crime of aggression being committed by a state comes before the ICC, there are a lot of other issues. Because if you see Chapter 7 of the United Nations Charter, where the Security Council has the power, it exercises several powers, and it also has the power to take enforcement action against any state that violates peace or commits a breach of peace. That is, violates the crime of aggression. And there are different ways by which a Security Council takes enforcement action against the state. Now, we are sure of one state committing the act of aggression against another state. There is also a possibility of the other state repelling the attack or the aggression of the aggressor state. That is, the state has the power to retaliate under Article 51 of the United Nations Charter, which falls under the concept of self-defense. Now, who has first used force is a question that needs to be decided. So, if the case comes up before the ICC, then ICC probably has to investigate not only the state which has first used force, but also the other state which has retaliated equally in force and causing a lot of damage to the state. So now we have two states which may be guilty of committing the crime of aggression. Of course, the first liability would fall on the state that has used force initially, first, then on the second state. So this is my submission.
And just before, Professor, allow me, Dr. Marotta.
Yes, of course.
Great force. Yeah, thank you, Professor, for bringing the issue of force. Actually, the definition that goes to the very root, the definition of that act of aggression. What constitutes really the act of aggression? We have to look at the fact that aggression is constituted by illegitimate use of force by, one state against the other under the command of an individual, either political or military. It could be, politically inspired, or it could be some military might, people trying to flex their muscle. I just wanted to just to reinforce what you have stated, that now under that particular framework, since by definition this offense is illegitimate, illegal use of force, we can have exceptions. One exception is where there's self-defense. When the use of force, armed force, was directed towards self-defense, that constitutes a legitimate defense in terms of the definition of the crime of aggression. Secondly, where the Security Council authorizes the use of force, as it has under the UN Charter, it has done, that also will constitute legitimate defense in those respects. I just wanted to support what the professor, my learned colleague, the professor, was saying. So those two factors would have to be borne in mind. There has to be legitimate, there has to be illegitimate use of force to constitute that offense. And therefore, by definition, we have defenses. Self-defense. If a country is fighting to defend itself, then it would be exempted from being criminally liable for that particular offense. Two, where the Security Council has actually authorized lawfully the use of force, which it has done previously. That would be in the interest of peace and security globally. And that would be by virtue of the UN Charter provisions. The other thing, maybe before I leave, we need to look at, back to the definition, which you mentioned, the professor, earlier. There are key elements that you mentioned, which we need to reemphasize. There's the issue of planning in the respect of food, the conduct. There's the issue of planning. There's the issue of preparation and initiating, and finally executing that particular plan. So when we come to the leadership clause, trying to establish the essence and the elements of that particular crime and the conduct, the individual behind, this would be very, very critical. And as I said, the other aspect which is critical is the threshold clause, because like the ICC would not, in even the offenses of crime against humanity, they will not take every other person. They take the main players. So the threshold here would be looking at the gravity, the scale, as you already mentioned. How heavy was this particular attack? So it's not just every activity which would amount to a crime of aggression, no. The elements they have to look into the gravity, the scale of that attack. If it's just a mere one border shooting, that would not be really aggression per se in terms of the act. So those are very critical points that we need to look at as well. But I was just trying to reinforce. So the gravity, the character, and when you talk about the character, the nature of that particular attack. So there's so much that is involved to be able to define what this offense is. And it's argued really that even up to this point, there's still no wholly acceptable position about the definition of this particular crime. So thank you, Prof, for that. And I hand you back to Dr. Marotta.
Thank you, Professor Milton, for your participation.
Dr. Marotta.
Yes, of course. Professor Frimpong.
Yeah, I just want to ask two questions which will help us in going further. I think you gave us a case which happened about 2008. We haven't discussed it further.
Yes, correct.
And then I want Professor Sipati also to, together with Honorable Merton, to consider whether a legitimate defense in repelling aggression can itself at some point in time become aggression. Is that clear?
Yes,
Yes, Prof.
Professor.
Yes, yes.
Very clear.
Well, from my side, I would like to say that when one state uses force against another state, the first step that the state that is being attacked or where force is being used against must inform the Security Council. Until the Security Council takes enforcement action against the aggressor state, this state has the right of self-defense under Article 51 of the United Nations Charter. So when it uses force to repel the force, it is legitimate. But once the Security Council is informed and the Security Council starts taking enforcement action, then the right of self-defense shall cease. The state which is repelling the attack cannot exercise the right of self-defense anymore because the Security Council has taken enforcement measures. So as long as the Security Council does not take enforcement measures, the right of self-defense exists and it is legitimate. The force that is being used. That is my submission.
Okay, just also to reinforce on what Professor Dr. Sripathi has very ably put across. I would want to address this particular query, Professor Impong, by revolving around what the statute states. We've just seen that when we look at the clauses to determine the definition, actually the act, the elements that constitute an offense under this statute, we'd also need to consider the fact that, as I said, there are three key elements that the statute would look at. First of all, I'll just put it on plain thing. Is that legitimate force that now you say has turned out to be, you wondered whether that legitimate defense to repel an aggressor would finally turn out to, that depends wholly on the circumstances. It should revolve, in my humble view, around three aspects. One, the character of that particular act, the character, the scale, as I said last time, and the gravity. Those are three critical issues that the court would concern itself with in interpreting whether, of course, I'm assuming it is the ICC who might decide, that might decide whether that particular force amounted to legitimate use of force, because in trying to establish whether an offense has been committed, they would want to ask themselves whether it satisfied the definition of the offense. So the elements would have to be looked at. So the first thing they would want to check is, what is the character of this? Was it excessive force? Did it repel and then it went beyond repelling? Just to reinforce what my colleague, my learned colleague, Professor Sipati has stated. I'm just supporting everything that he has indicated. I'm only enlarging it, increasing the jurisdiction a little bit. So the court sitting, if I were be sitting as a judge, I would also want to question, I would want to address myself and satisfy myself as to the gravity of this particular attack and the scale. You've always heard that this is a full-scale war that has been lodged. I would also want to look into the scale. So these are the three guidelines that have been granted, given to us. By analyzing this based on the facts on the ground, to determine whether the legitimate force initially had been issued as now hitherto was legitimate is now illegitimate. So in my view, it should depend on the factual circumstances of each given case. We'd have to give a factual interpretation in any given case, and that would determine whether or not the legitimate force has been exceeded. Basically, I'm talking about exceeding because we can't undersede. Thank you, Prof.
Yeah, with hindsight.
The force used must be proportionate to the attack.
Yes, absolutely.
Yeah, with hindsight, how would you describe the invasion of Uganda by Tanzania to remove Idi Amin? Was it legitimate and proportionate?
Okay, I assume, Prof, you're talking
maybe
about...
you can explain to other participants if they are not aware of what transpired.
That's what I'm getting to. Maybe you picked because my name Milton Obote. That's right. Yeah. Ladies and gentlemen, my distinguished colleagues, professors, I'm talking about the situation in Uganda where the invasion took place around 1978, 79. That is when Idi Amin, the dictator, was in power, and it was a very autocratic regime. They lost lives, over 500,000 Ugandans passed away. And so there was need to be able to topple this government. And the only feasible means was by way of armed struggle. But now, there's one point which I need to bring out. The kind of war that was waged during this time was a guerrilla warfare, meaning there were units that were fighting a government-established force that was in place. What was done, this would be essentially within the purview of the war of conflict or of warfare. But just to narrow down the whole thing, it was war between individual units, resistance groups. It was not Tanzania as Tanzania fighting Uganda. It was Tanzania supporting the revolutionary forces that were aiming at toppling the government of the day in Uganda, that of Idi Amin. So we had groups.
I can cut in here to, maybe you are too young to know what I'm referring to. Idi Amin,
yes,
originally was the aggressor by invading Tanzania.
I was coming to that point.
Oh, okay, thank you.
I was not young enough. And I'm sure Council Grace Okot would also be, perhaps she was younger, but she has the background. She's the one who's there. You're very right, Prof, actually. What happened was this small, the attack, it was a small attack that Idi Amin tried to take over a particular region and try to annex that part of, it provoked Tanzania, in fact, because he was worried about the unceasing attacks of guerrillas. So he moved in and attacked and tried to annex some part of the land of Tanzania. So that provoked an attack. But Tanzania was very smart, did not want to attack as a country. It also involved the nationalist fighters. That's where I was bringing in the other elements, including the FRONASA that Museveni was involved in, the elements that were supporting the former president, Milton Obote. So all these waged war, and there was a combined, the Tanzanian soldiers were there themselves involved in battle, combat. So you are right to that extent. Yeah. So that was war in terms of trying to defend, it's repelling an aggressor, which is legitimate. But now that's why Tanzania approached it from a very tactful way. Once it had repelled the aggressor from its territory, it allowed the nationals of Uganda to proceed with that other fight in. So it would be like
they went.
Yeah, they went
with troops.
They were in. I saw them myself. I was in that country. I was in that country that particular time. I saw the Tanzanians, but they're all mixed up with the Ugandans who are fighting right from Tanzania. But anyhow, just to bring it into perspective, the idea is whether that fight, I think your point, Prof, is whether the invasion of Uganda by Tanzanian forces was legitimate. So we can focus on that one. Let me leave that to the senior professor, Dr. Sripati. What's about Dr. Rama? Let me not grab everything. They can argue around the concept.
Ready.
Yeah?
Now,
Professor Shipati.
I would say that guerrilla warfare does not fall under international armed conflict.
Mm-hmm. You see the words coming out.
International humanitarian law, we have international armed conflicts and non-international armed conflicts. So the example given by Professor Emeritus is an issue that falls under non-international armed conflict. Although we see Tanzanian individuals supporting the revolutionary groups in Uganda, it still does not qualify as an international armed conflict. And therefore, we cannot say that, and of course this happened when the ICC did not exist. ICC came into existence only in 1998. ICC would not be bothered about incidents that have taken prior to the coming into force of the Rome Statute.
That's a good point you've raised, actually. That just get my attention.
No, please. I'm not suggesting ICC should try.
Yes, I can understand.
I'm looking at it from our current situation.
Yes.
That assuming for purposes of discussion, this should happen.
Yeah.
If you go particularly to my region, West Africa, where ECOWAS and others have gone to what do you call Côte d'Ivoire to remove in quote dictators and so forth, and recently in Gambia. So we cannot forget about what transpired in what you call Uganda, Tanzania. But contrary to what you are saying, it wasn't internal guerrilla warfare as what Professor Merton is trying to tell us. Truly, the then Nyerere President Nyerere openly declared that no, if you have brought the war to us, then we are coming to you. So they really released soldiers to pursue all the way until they got Idi Amin overthrown. So it was in those days what Tanzania thought was legitimate, but with hindsight, I'm asking whether under our current Rome Statute, we can classify that as a legitimate, because your self-defense has gone beyond self-defense, and to the extent that it has now become a crime of what I would consider aggression because of the extent of the force that was used, to the extent of even overthrowing the regime. So that was the reason I wanted us to look at it. And then you can also look at the question I posed about sorry, Professor Marotti, whether the case he presented to us is something that we don't need to discuss. Because if you enter into a territory in hot pursuit, does it ever become aggression at some point in time? So these are some literary issues that we need to address. And thankfully, Professor Shipati is here, the expert in these matters, to help us.
Yeah, I think that's a good question, Prof. We understand it the way you understand. I hope even the professor understands. So you can continue. I think you can go ahead, Professor.
Suppose the Uganda-Tanzania situation. Disturbance. As pointed out by Professor Emeritus, the situation of Uganda and Tanzania, if arises today in the world, after the coming into force of the Rome Statute, probably ICC may have jurisdiction to proceed against the aggressor state. Because use of force has been employed by one state against another state. In other words, the crime of aggression has been committed, and therefore the ICC gets the right to investigate and exercise jurisdiction against that state. A similar situation happened in India and Pakistan, where Pakistani terrorists waged a war against Indian army in Kargil. Kargil is a place on top of the Himalayan glacier. So a lot of Indian soldiers were killed in that conflict, but this did not qualify as an international armed conflict because of the, the nature of the conflict. Because for an international armed conflict to be a legitimate conflict, the states must be in a continuous state of war. Hostilities must continue. There should not be a break in the hostilities. Whereas in the case of the Kargil issue, the conduct of hostilities were sporadic. They are not continuous. So it does not qualify as an international armed conflict, and also the use of force cannot be applied to such conflicts because of the sporadic nature of the conflict. It is not a continuous state of conducting hostilities. Only where war is fought in a continuous manner, only then the issue will qualify as an international armed conflict, and the ICC may have the jurisdiction to proceed against the perpetrator of the crime of aggression.
Just to reinforce again, before I would even want to hear Council Grace Court say something about that country where she comes from initially. But before that, there are two things I want to raise. As we said, the ICC, just generally international criminal law, as I always said, the literature of the law has been very slow to develop a lot of themes, interpret them. It has been really slow. This is one area, because now we tend to focus, we are looking at the crime of aggression because today we are on that. But your question, I believe, in my humble assessment, would have to bring in the other crime also, which is under the statute, the war crimes. We would have to look at whether that could be looked at in the light of the war crimes and whether we have any suitable jurisprudence of the International Criminal Court that has addressed that particular issue. I wouldn't say I'm prepared to indicate any jurisprudence with respect to that. So this could be a confluence between aggression, but we might also need to know to what extent it would amount to certain elements of the war crime. That is a bit stretching it too far, but I'm just trying to say for analysis purposes, we may also need to look into the other aspects. Why am I saying that? I'm saying that because so far, since the activation of the crime of aggression, we don't have any significant jurisprudence that has been generated by the International Criminal Court that could provide some guidance on interpretation of some of these statutes provisions. So we hope that with time, once there'll be an opportunity for the court to litigate, to preside over a litigation relating to any of this, it would seize that opportunity. I hope it would seize the opportunity to expound on jurisprudence that would guide us in respect of some of the aspects, not just what Professor Frimpong has just raised, but many other facets of this particular crime. So now we're still limbo in darkness, in some kind of vacuum, because there's not been any legal expounding, authoritative legal authority on many of these aspects. That would be my, by the way, observation, but it is subject to contest anyway. That's just a personal view. So I was saying maybe Council Brenda could be having something about that country where she belonged, I think, long time. So Council.
Yeah, thank you so much.
Yeah.
Yes, thank you. Thank you so much for this little opportunity. It's unfortunate today I'm driving all my way along. So it's a very interesting topic. I would have loved to participate better, but the traffic didn't allow me today. It was quite heavy. Otherwise, when it comes to Uganda, I was quite so young by then, but I remember vividly in our household that we had Tanzanian soldiers in our house. That is to bring peace in Uganda. So I was still so young, and my father was taking care of them. So we had them at home, and it is true that it was Idi Amin. According to history, it was Idi Amin who was the aggressor by then. Even if he did not go very far, it was the president of Tanzania, the Nyerere of that time, of course, who went as a defender to defend his territory, but at the same time took the advantage to come in and save Ugandans from the dictator. So in that case, the power, the power of aggression, that is the power used, or the energy that was put in, was, I think, excess compared to what a defendant should have used to defend his own land. As Emeritus says, I think if this happened at this time, maybe the ICC would be definitely involved. But to what extent is what I don't have an idea. How the ICC would, is what I would like to know. What would be the measurement of the extent of the aggression? Thank you.
Yeah, that's good response. We got first-hand information. So anyway, I think in the absence of any, just to close it, my submission, in the absence of any authoritative interpretation of any of the statutes, would still have to go back to what the definitioner would have to look at the scale, the gravity, and all these elements to see whether there's been excess use. And the question I would pose, that what would happen if the argument is put on the other side that there was the propensity that if this was not taken the whole way, there was a propensity that the person who was being repelled could still make another comeback. So the idea was to push them as far as possible. I'm not saying that's the position I'm putting across. I'm just putting it for the sake of argument, for analysis purposes. But anyhow, those are our submissions. Maybe Dr. Rama would want, Professor Rama would want to talk, or even Brian. Maybe you have something to close over that issue. Any of you, welcome. If not, I hand it back over to Dr. Marotta. There's no problem. That was a very novel area.
Generally, I would like to just add one thing here to what Brenda has put forth her question, saying that how the gravity can be measured. So generally, in case of aggression act, if it is limited to a particular country or within a particular state, if it is limited to the forces like a civil war which is taking place within a state, then I don't think so we can call it as an international conflict or armed conflict, which can be brought under the perspective of aggression or crime relating to aggression. This is an addition to what Professor Dwarkanath sir has mentioned. So I would say that it would take the form of aggression only if it is of such a gravity that it is going to hamper the peace of the world nations put all together. So until and unless we cannot call it completely to be under the ambit of crime relating to aggression. So the aggression has to be much more than just limiting itself to the civil conflict which is taking place within the nations. That I don't think so Security Council would also be interfering in such matters. One example here is Palestine and Israel. So Security Council, even though it tried to set up a mediation between these two states, the mediation was unsuccessful. So it has just left it to the states to determine the boundary issues and all relating to how the division has to be made. So these even the aggression or the civil conflict is still going on within the state, but we cannot consider these kind of acts as a aggression or the crimes relating to aggression. And when it would become a crime relating to aggression is when it takes the form of international armed conflict, which would in fact become a matter or the concern of the world communities at a large, which is this because of the armed conflict that is going on between the nations. It is impacting the peace of all the world nations. Only then it would take the form of a crime relating to aggression. So this is my view, and I can be corrected on this.
Just
Thank
the
you.
last point on that. It's good that you raised that. Allow me, Dr. Marotta, to just reinforce that. You've raised a very important point, I think, which was almost escaping our attention for a while. There's some very characteristic feature about the drafting of the offense of crime of aggression, something that we do not bring forth. This is, you'd find that in many instances, it has been tied to the United Nations Charter. In fact, the definition is, when they talk about the character, the gravity, and all those aspects, in the end, they say a violation which would be a violation of the provisions of the General Assembly definition of aggression. There's a tie. If you check properly, it is tied to the 1997 General Assembly, 74, I think, General Assembly definition of aggression. And this is why we are saying that in the absence of authoritative interpretation, because this will now call in authoritative judicial interpretation by the judges of the International Criminal Court. So the first time or any moment there'll be an opportunity, I believe the judges will be able to set out the limit. This will be a very discourse area, a very fertile area for the counsel on both sides to be able to put their contrasting views and build up a definition for particular terms, expansion on the limits of what character is, of gravity, of the scale, because these are tied, and also interpreting that very definition that is provided for in the UN General Assembly definition. So it's important what you brought, Dr. Rama, that was very good, Professor Rama. Most of these things are tied to the definition. So it means we have to take recourse, we have to have recourse to what the General Assembly definition of aggression means. And then it's interesting, later in the statute, it is said that we are nonetheless not bound by any interpretation that comes out by an organ which is not within the ambit of ICC. The ICC will not be bound by some other interpretation elsewhere. So it's a very complicated cobweb.
Yes,
so that is it.
it is
I think Prof
abstract.
has just gotten out, but that was, I think it's good you brought that area. And I believe Professor Sripathi also had it in mind as well when he was advancing his argument. The actual talk of 1994 General Assembly definition of aggression. When you see the character, gravity, and scale, which is a manifest violation of the UN Charter. So it takes us back to the UN Charter.
I mentioned it in my initial discourse.
You did that, Prof.
The gravity and the scale
Yes.
decide whether it is a legitimate crime of aggression or not.
That's right, Prof. You did mention it. It's only in our arguments, in our analysis, you missed it. I missed it myself in my analysis.
Even in 1998, during the 53rd session of the United Nations General Assembly, the Chinese delegate by the name Q Wensheng had made a statement. And according to him, the crime of aggression was dealt with in the statute in a highly ambiguous manner. His delegation had no objections to the crime of aggression being included within the court's jurisdiction, provided that a proper definition of the crime could be arrived at. As such, a definition had not been yet agreed upon. The inclusion of the crime in the statute would not only render the court incapable of exercising its jurisdiction over such crimes, but would rather complicate the definition of aggression, and such a move was deeply regrettable.
Brilliant.
This statement made by the Chinese delegation during the 1998 53rd session of the General Assembly.
That's very brilliant. So we are left with how the court would be able to interpret the applicability and the nexus with the General Assembly, definition. All right, I can see. I hand over back to you, Dr. Marotta.
Okay, thank you, Professor.
Dr. Marotta, still you haven't addressed my concern.
Oh yes, of course. I was waiting the answers of the other panelists. Well, the reason why I brought this case about 12 years ago was I want to see the point of view of my other peers that are sharing the desk related to that issue, because remembering doing the search for the case that I have in my archives, it was it was not after the investigations related to what happened in the border of Colombia and Ecuador. It was not really a hot pursuit. It was really they found a location of this FARC camp, and they decided to bombard it from Colombia to Ecuador, because I'm just checking the press release of those days. Many of the corpses were found under with pajamas and underwear. They were not. It was not really a hot pursuit. So, and after the intervention of Professor Shipati, it was an isolate. What happened there was an isolate situation between the military forces from Colombia against this terrorist group. That the FARC, that was a terrorist group. Now it's no longer, because they entered into a peace process about 3 years ago in 2017. However, I have in mind, because when it happens in March of 2008, with the Andean Commission of Jurists here in Lima, we made a course related to the International Criminal Court and the Andean region, because there is, like, here in Latam, Colombia, Venezuela, Chile, Peru, and Ecuador. They are part of the Andean Commission. So we made a course that was financed by the Canadian government, related the relation of these countries with their case law and everything to the ICC. And I brought it here because I now remember that the name of the president at that time, Correa, he made some discourse related to the crime of aggression. But we know that we are scholars that there was no, in that moment, was not really a crime of aggression, because it was an isolated case. So, but the idea was to bring it on the desk, was to deep more about what we are challenging from now on into the near future in relation of that also I brought it when we started, the ones related, for example, cyber warfare, you know, how if we can consider cyber warfare as a type of crime of aggression. So that was the reason why because my mind sometimes acts very quickly, and I remember having this face of President Correa in the news addressing his country, and it was passed through CNN, and he mentioned, oh, Colombia has made a crime of aggression because blah blah blah, they bombarded, we didn't know this, it was under our territory, and it was, I remember in those days they have to call for an assembly in Washington D.C. in the office of the Inter-American Commission to deal with the problem. So, but in the end, as Professor Shipatri has mentioned, and also Professor Milton, for the crime of aggression, it has to be a continuity of that aggression between two countries. So, and also as the example that gave from Uganda and Tanzania. So for summing up and to give it a kind of resume, so we now understand what is really considered crime of aggression as an international crime, as an international war crime that needs to be a continuity. So that's the reason why when we started this discussion, I brought to the desk the cyber war that we're going to have, that is going on and is going on in the future. I mean, so if that also can be considered from country A to country B to do a mass attack of their pumping oil, if they have oil, electricity, water, if that also can be considered a constantly crime of aggression. Because, I mean, we have this conception of mass destruction through big weaponry, as we used to the knowledge of how war was made in the past. Nowadays, war is going to be very different. We are going to have, in the near future and in the future, we have scenarios that our mind only in science fiction movies, we only have seen it. But I guess that after we succeed of this international pandemic, probably we're going to see more actions from China to interests of Europe or interests of the US related to doing mass attacks of cyber mass attacks through hackers to very logistics regions of, for example, electricity, power, or water, or even gas that are now controlled by computers. If that attack and be continuously could be considered also a crime of aggression. As I explained, sometimes the hospitals, the more vulnerable under these cyber attacks are hospitals or daycare of centers for elderly people or younger ones. So and if they don't have, sometimes there's the electrical equipment, they don't react very quickly. The ones that are for when there is a breakout of energy, they have their own electrical mini powers in their own buildings, but the reaction times of that systems, sometimes it gets in 5 or 10 minutes. Many people could die if it's done for example, as doing an example of country A to country B, and they shut down all the country. Many people will die if they are in the hospitals, for example, under this situation of the pandemic. They need this ventilation, respiratory equipment to support their lives. So now that that answer that have been spread out, that we need a continuity of the aggression, and also that it's been lighted out. Also, I bring again to the desk what are the challenges for the future? What we can consider crime of aggression of for example, cyber warfare, could be considered. And for example, these hackings, these mass hackings, not for taking information, but for shutting down energy power, the things that are very geopolitical cores of a country: electricity, gas, water. Also, if they shut down all the systems, how do you control your airspace? So, what do you think? Do you consider that will be the cyber warfare of the hackers in the near future to be considered a crime of aggression? New types of dealing with the way we are going to see how war is going to be from one country to another. Now that everything is under the control of artificial intelligence.
Now, what Dr. Barota has stated is a situation that falls under cyber crime.
Correct.
Now, we also have cyber terrorism.
Yeah, that's true.
Initially, many people thought, including myself, that cybercrime and cyber terrorism are one and the same. Until I read a few articles, and one of the authors of these articles made a clear-cut distinction between cybercrime and cyber terrorism. The instances that Dr. Marotta had given of hacking computer networks falls under cyber crime. It is not cyber terrorism. Hacking the banking network system. People may lose money, but apart from that, no harm is caused to their body. So it amounts to cyber crime. But in the case of cyber terrorism, the element of fear in the minds of the people is the most essential factor. For instance, in many countries, the railways are run by computer networking system. So if someone manipulates or hacks such a network system, there is a possibility of accidents taking place. Similarly, a computer network system of a country which operates the aircraft, the computer system in the traffic control tower in an international airport. If that is hacked, there is a possibility of planes crashing against each other. So if such things happen, a kind of fear psychosis comes into the mind of the people that if they board a train or an aircraft next time, there is a possibility of an accident happening and that they may lose their lives. So they refuse, or rather they keep away from boarding a train or an aircraft. This kind of fear psychosis that is created in the minds of the people by terrorists, by manipulating the networking systems, is cyber terrorism. So that's the distinction between cybercrime and cyber terrorism. So it does not actually fall under crime of aggression.
It is more a character of international crime. So when it is taking the character of an international crime, all these terrorist activities, any state can punish the offender if at all if he is found under international law. So it is not a mandate in like only ICC has to try the offender if he's committed any kind of international crime. International criminals can be punished by any court of any state. That is very much acceptable under the UN Charter also, that any international crimes, the jurisdiction lies in the all the states. So anyone can try the offenders there.
Yes.
Cybercrime
thank
is
you.
actually a broader
Yes.
concept. I mean, we cannot consider it as in under the crime of aggression, and it would be better if we take a separate panel discussion on this topic in the next.
Just now. Can we postpone it? Probably after 30 minutes or so. After 1 hour. 1 hour, I think.
Yes, Maurice, we can make another topic related to cybercrime.
Because cyber
Yes.
terrorism,
And
cyber crimes, cyber organized crime, there are different types of the crime. So
yes, correct. Related to cyber warfare and ICC, for example,
yeah,
that was very useful because that's are going to be the challenge we're going to face in the coming years.
The future.
Okay.
In the future, we might face.
Yeah.
Yes, and I mean it's right around the corner. We didn't see COVID-19. We're going to see something like that in the. I mean, it's amazing what, and every time if you check these all news related to cryptocurrency and all the amount of cyber hacking that or cyber terrorism, as Professor Tripati has told us. I mean, always all the company, for example, the flying companies, they always have like, what happens if they have like this training their pilots and their underground operators if they are under a massive attack and they don't have control of the plane. I mean, because right now the planes are controlled by automatic systems that I think the 99% of if you see Airbus or Boeing, their aircraft are controlled 99% by the computer system. The only thing that the pilot do is take off and landing. That's all. So they are trying to rearrange that under this kind of situation that can happen or could not. So they need to be prepared or what happens. The rail system, for example, as Professor Sripati mentioned, in many countries they are also controlled by artificial intelligence, and if some person decides to take that control, it is very common now as a fire sales in the wording of the technologies. I mean, it's going to be a very difficult way to control. I mean, they can use that as a weapon, train system. If for example, in Europe, many gas is transported, or many many chemicals, gas, fuel is transported through train systems, so it could be used like a weapon. So yeah, it's very interesting. I can share that with Professor Milton to do a next session related to cyber warfare, cyber crimes, and the international criminal crime.
As this topic has just started off relating to cyber warfare, there is also a bio warfare. So most of them have this conception that COVID is a bio warfare. Can the states be made liable? Yes, I would say then bio warfare would be a proper act of aggression only, because it is just it hampered the world economy at once. So if it is a bio warfare and if it is proved against the state, then no doubt the state will be directly made responsible under international law. So this also is a very emerging area for discussion. And lastly, I would just take a minute to conclude with respect to what Professor Frimpong has put forth. the war that took place between Uganda and Tanzania, directly there were involvement of military troops. Okay, so the involvement of military troops belonging to both the states were there. So it ultimately depends on the state responsibility, directly on the states which has actually called for the aggression first. So whichever state has first started the aggression activity or the conflict activity, that state will be directly made responsible, because there are no non-state actors here, like violent non-state actors or any other groups involved here. It is directly the military forces which has attacked the other state. So as the involvement is there directly by the state will be made liable under international law. And if it is happened in the present time, no doubt, as the state is the perpetrator, probably the military person, whoever is in charge of the military activity, will be made liable under the International Criminal Code. That is what is my contention. Thank you.
Yeah, and what Professor Rama said before this, the other one, preempted what I wanted to say, and I just want to say thank you. You might wonder, what is it you said? Thanking you. I saw you analyzing character. Actually, that was what was in my mind, because when you talked about character, because if you had to see the scope and magnitude and what it is, I think it boils down to what the character of that particular activity is. So thank you for raising that one. So you saved me. I didn't have to talk about it. Okay, and I also want to indicate Professor Frimpong has left with our leave. He had something urgent, so he didn't just disappear. He asked for leave. Dr. Marotta, over to you, sir.
Yes. Yes, of course. Yeah, sometimes he's in a hurry, maybe. And yes, to continue with the discussion. I mean, what was brought to the desk, and we have discussed about the crime of aggression and implication of for states parties, as have been explained by Professor Sripati and the other colleagues that we have here, like Manrit and Professor Gutalama, and Counsel Brenda, that she tries to handle a little bit this discussion under driving situations. I mean, there she is.
Yeah.
She's back again. She
landed. Right, not like that.
Yes, she landed.
That time she was upside down and saying, "What's happening?"
Yes, but now
she's very committed. She can drive while attending this webinar.
Yes, of course.
Well, I was just thinking aloud, and I'm like, okay, in that case of Uganda and Tanzania, if it so happened, now I'm wondering at what level would it be taken to the ICC as an aggression? Because this was a dictative government, of course, and then there was victory to the citizens and they were happy. And the peace was, I mean, their rights were taken over. And this time they got the peace they wanted. So at what level would this case be taken to the ICC?
That's a good question. Rampane, you want to try Ramampane? Would you want to try, Mr. Rampane? Oh, sound.
Yeah, there he is.
Oh, sound. Okay,
Hello,
can you talk? Oh yeah, we can hear you now.
There he is. Yeah, there's Brian.
Okay. I may need her to repeat the question again. I didn't hear her properly.
I was wondering at what level the aggression would be taken up in this case of Uganda, Tanzania by that time. A state of dictatorship, and it has, of course, caused aggression. It went and started its own, I mean, it shot itself in the foot by going into Tanzania, and Tanzania retaliates and goes deeper in to save the state. Now, when it comes to today's, because that was before the ICC, but right now as we stand, at what level would the aggression be measured at? or be brought up to the attention of the ICC? Is it at victory? Is it at the beginning? When and how?
Thank you very much. I'm not quite very sure about my answer, but what I would like to say is I think the test is going to be the reasonable, whether or not reasonable force was used, and if whoever will be presiding is of the view that even at victory reasonable force is used, then I believe then to be presided like that. So the difficult question about use of force is what amounts to reasonable force, and if you defend yourself, to what extent can it be argued that it's reasonable? So I think through various cases, it has been argued that it depends on case-by-case basis on whether or not your self-defense was reasonable, or looking at the veracity of whatever force that was used. Thank you.
I think that is a good attempt. Just to reinforce onto that, I think, in my view, would first look into what the definition of component is, because you're asking who, when. So you can see that it entails planning. When we look at the definition of the act itself, first of all, the act, it can only be brought for action when the act itself has taken place. There must have been an act of aggression, the conduct itself. So the other thing we need to look at is whether if there was a planning, because we have to hold somebody responsible. There's the leadership clause. We have to invoke the leadership clause. If Tanzania attacked Uganda, we are not actually not going to deal with Tanzania as a nation. There must be someone there who was responsible for the planning, preparation, a group of people. It may not be one person. That's how it has been argued. It could be even 5 persons or 2 or 3, but they took some effective control of the military arrangements, that side of the political initiative. So that has to be looked into. And then as to when that would come before the court, I think that would entirely depend on who comes to court for a cause. When they lodge the thing, it's a very interesting question, very complicated. Let's see what Professor Sripati has. He has the keys to some of these very complicated things. Yeah. Maybe you have something for us, Professor Sripati.
So in my opinion, the answer is very simple.
Yeah.
Because they have to look at the issue of cases being referred to the ICC.
Yeah.
One is firstly state referral.
Mm-hmm.
In Uganda's case, Uganda has been happy.
Mm-hmm.
Case would not be referred by Uganda to the ICC, isn't it? So there's no complaint from Uganda. If you referral, Security Council referral, since both the countries, Uganda and Tanzania, do not have any complaints, why will the Security Council interfere? Coming to the proprio motu power of the prosecutor of the ICC, where the prosecutor can take up investigations against the perpetrator of a crime. Now again a question arises whether any of the two parties are members of the Rome Statute. That is an issue that needs to be addressed first. If they are parties, there is no issue. That prosecutor can proceed with the investigation upon the approval of the pre-trial chamber. But if one of the parties is not a party to the Rome Statute, or even if both the states are not parties to the Rome Statute, then the prosecutor will have problems. This is my opinion.
I agree with you totally, Prof. It's a question of trigger mechanism.
Yes.
Absolutely, and you brought it very right. It's either the prosecutor proceeds proprio motu, or either there's a state referral, just as you said, if one of the parties is a state party to the Rome Statute. So I think, or the Security Council decides to step in if none of those, if the aggression actually offends against the provisions of the UN Charter relating to peace and security. I totally concur with your views to that extent. Yes, Dr. Marotta, you might be having something to. Okay, we can't hear him. We can't hear him.
Muted.
You have,
Yes.
okay.
Yes, I was muted.
We can hear you now.
Okay. Yes, no, I was
Just
listening.
before you say, Professor Rama just indicated her power just went off wherever she is, so she's excused on that ground. Electricity just disappeared, so she's offline. Okay.
Yes. No, what was I saying was I was muted. I just heard the presentation of Professor Shipati, and this was very eloquent and very high skilled, and also to take in consideration what Manrit shared with us, to have a next session related to cyber warfare and cyber crime and cyber terrorism and the international criminal court, the ICC, how this new, if this, and also what I think also was Professor Gudamela before she left, related to bio,
yeah,
yes, weaponry, biochemistry, or any of this, also to be considered as a crime of aggression.
I'll work on that.
Yes, we can use the I'm going to share with you, Professor, and then you can share with related to what Professor Gudamela told us, also to have another session related to bioweaponry. This tort claim that was made I don't know, 3 or 4 months ago by this law firm against China, between the U.S. claiming all these money losses in the U.S. So we can use that for a start.
That's right.
Professor Gudamela recommendation. Okay. So anyone else before we close this meeting want to add something?
Just my one last thought.
Okay. Great, Brenda.
Another tough one. But that was not tough for
No. I'm just thinking in relation to the ICC, with the duration of the cases taking hand, and how Uganda was a coup. It was a coup taken up, even if Uganda was the aggressor to Tanzania, and Tanzania reported it at that very time. With the duration of the case, and without any army or anything for the ICC to defend either party, how would they handle it? That's just my thinking. How would they go into a coup which has already started and it's just going very fast? How would the military action be stopped so as not to continue with the aggression apart from just a warning? Is the ICC well equipped?
Yeah, maybe someone wants to handle that. Generally, you know, there are a lot of challenges, constraints on the operations of the court, as it is even now with respect to the other crimes. We just discussed the other time the issue of Afghanistan, and we noted that the ICC, the Office of the Prosecutor, had challenges going into the theater of operations. We saw that the government of Afghanistan had invited the prosecutor to come and carry out investigations some time back I don't know which year that was, but they couldn't pitch up because of the security and how volatile the situation is. But in this particular case, even before we get to that point you're asking, the first question we would have asked ourselves, under what trigger mechanism, what has triggered the jurisdiction of the court? That would determine a lot of other things, because the Security Council would trigger that and refer to the prosecutor, but the same Security Council would have the authority, of course, to invoke the use of force, authorized force. Like we saw, it's one of the defenses under crime of aggression. When legitimate force is used by virtue of the authorization of the Security Council, it would be. But that would be getting a bit ahead of the thing. The first thing would be to check on the trigger mechanism. How? Who? Is it the prosecutor bring the matter? And who are the elements being, because everything here is threshold. They're not going to get every Tom, Dick, and Harry. They'll get the key players. So whom are we looking for here? Or are we looking for Idi Amin, who has already disappeared? or Malia Mungu? I remember those names. So entirely to depend on the trigger mechanism adopted, then that would follow how the prosecution would pursue the investigation. Because remember, there's always the investigation stage. And these people have to be brought before. And the ICC is 100% dependent upon member states to provide security, to provide enforcement mechanism. Even up to the level of execution of sentence, it is the members who provide jail where the persons who have been convicted can be placed in. So it's a lot of, it starts off with a trigger mechanism, just like our professor put it. And that is what we can say about it from my side. Unless my other learned colleagues have something to add on. Okay, if not, I think we would be planning to wind up now.
Yes, Professor.
Yeah.
Okay, thank you everyone in participating in this summit that we have today related to the crime of aggression and implications for the state parties that are part of the ICC. So we wait you of our next session on next Friday. We are going to see which program we are going to use. If you have any suggestions, you can send us an email to us, so we can also have more ideas. So which more issues related to international crime can be discussed over our every Friday panels. Okay, thank you, and thank you everyone for joining us today. And I pass the desk to Professor Milton for his last words.
Thank you very much, my learned colleagues, the learned professors of law. Today, it was a great day. We had many of our colleagues coming back on board after being absent. We saw Brenda coming up with the very tough questions about Uganda. We saw Council Maurit, who had disappeared. She was busy at the ICC. And of course, as usual, we were still here with Professor Sripathi, always taking guard. It was very impressive. And we have Rampane, who keeps time. He arrives 1 hour before it opens. He's always online. That's very impressive and encouraging. And thank you, Dr. Marotta, for that wonderful hosting indeed. And for those very vivid examples you give, which remain vivid, which are real, that you've had experience with. For those who are not here with us, we thank you too. And for our members and viewers all over you, wherever you are, we want to thank you very much for your patience. Today was one of the longest, and you've seen how the intellectual prowess of our professors have been demonstrated. They have really demonstrated their ability to grasp facts, as you have seen from everybody here. Thank you very much for listening and for watching. And from us, the panel of the professors, we say bye-bye until next time. Thank you.
Yes.
Thank you.
Bye. Thank you.
Bye.
Thank you.
Bye.